Let's listen about the perspective in China for the legal framework and legal grounds to compare the different practices. So, Ming, the floor is yours.
Okay, Claudia, let me share our slides.
Yeah.
Is that all right? Can you see the slides?
Yes.
Okay, thank you. It's good. So I will give you a brief introduction about the legal framework about the compulsory patent license in China. The legal provisions on compulsory licensing were incorporated into China patent law when it was first enacted in 1984. And after that, they have been through three subsequent revisions in 1992, 2000, and 2008, respectively. And the current version of these provisions was finalized in 2008. Now, in China patent law, there are 11 provisions on compulsory licensing in total. That is from Article 53 to Article 63. And these articles together form the main legal framework on compulsory license. And they relate to many different aspects. And the first four articles define the circumstances that a compulsory license may be granted. And the next two articles relate to a few limitations on some special circumstances. And then there are two articles stipulate evidences that should be provided if an application for compulsory license is to be filed. And there is another one article stipulates the authority who has the power to grant the compulsory license and also the procedure of registration and publication if a compulsory license is granted. There are two articles stipulate the rights and the obligations for the party who is granted a compulsory license for exploitation. And the last article is about the legal remedies for those who is not satisfied with the decision of compulsory license or is not satisfied with the royalty determined to be paid. So next, we will look at these articles in more details. So according to the China practice, the law permits the granting of compulsory license under four circumstances. The first one relates to patents that are not sufficiently exploited or the exercise of which is confirmed to be a monopolistic conduct. And the second one is the situation where a national emergency or extraordinary state occurs, or the public interests so require. The third circumstance is for the public health. In this case, the compulsory license can be granted for manufacture of pharmaceutical products and exporting it to the countries or regions that comply with the provisions of the relevant international treaties that China is a party. This article was actually incorporated in 2008, since China became a member of the World Trade Organization in 2001. And the last circumstances is about the patent cross-licensing. It is quite similar to the dependent patent in Brazil, as Claudia just mentioned just now. But in China, there seems to be more limitations. It requires the patent to have a major technological advancement of remarkable economic significance, which is really hard to meet the requirement. So in this case, if the exploitation of this patent depends on the exploitation of an earlier patent, then a compulsory license can be granted for the earlier patent. And also in this case, upon the request of the patent holder of the earlier patent, a compulsory license can also be granted to exploit the latter patent. And in China patent law, it is specifically defined that if the compulsory license relates to a semiconductor technology, then the exploitation shall be limited to the purpose of public interest and the circumstances regarding monopolistic conduct. And besides, except for the compulsory license granted because of the monopolistic conduct or the public health, the compulsory license shall mainly be exercised for the supply to the domestic market. And if one would like to file an application for a compulsory license of a patent, then they have to provide evidence to prove that they have made a request to the patentee with reasonable terms, but they cannot obtain such a license within a reasonable period of time. So in China, the application for a compulsory license should be filed to the Patent Administration Department, which is the China National Intellectual Property Administration, and we call it CNIPA for short. And the CNIPA will also make the decision. The China patent law also stipulates that for one who obtains a compulsory license, they does not have an exclusive right to exploit, and they has no right to permit others to exploit, and they also need to pay royalties to the patentee. The amount of the royalties can be negotiated, but if an agreement cannot be reached, then the CNIPA will make the decision. The last article is about the legal ground for legal remedies for those who are not satisfied with the decision of compulsory license or the amount of the royalties decided by CNIPA, and we will discuss this in more detail later. And at last, we would like to say that although up to now, no compulsory license has ever been granted in China, but these legal provisions still provide us with a potential tool to protect the public interest and against the abuse of the patent right. And thank you.
Thank you very much, Ning. As we can see, we have many similarities with the Brazilian practice regarding the requirements for declaring a compulsory license, and it's particularly curious that your law has specific provisions for public health in pharmaceutical area and also for semiconductor.
Yes.
So now let's see about China, and I would invite Wu Tian to come to the floor.
Thank you. And I will continue sharing the slides. Yes. So before I start, here is some explanation that in China, when we talk about compulsory licensing in a narrow sense, we are referring to an administrative process where the patent office officially grants someone permission to use a patent without the patent owner's consent. But this has never actually happened in practice, as we already informed. But our courts in judicial practice have handled cases which basically achieved similar results. So when the courts find patent infringement, Instead of forcing the infringer to stop using the patented technology, the court ordered the infringer to pay reasonable fees and allow them to continue using the patented technology. It is like a compulsory license in a broader sense, not exactly the administrative procedure, but ends up serving the same purpose. When the court makes these rulings, they are mainly following the two principles from the Supreme Court's order and spirits. The one is significant imbalance of interest between the parties, and the other one is public interest. For example, as shown in these slides, this is a Supreme Court judicial guidance announced in 2009, and it states that if seizing the relevant act would result in a significant imbalance of interest between the parties or be contrary to the public interest, instead of ruling to seize the act, alternative measures such as more substantial compensation or economic indemnity may be adopted. And similarly, some Supreme Court judicial interpretation also have cited the similar rules. Like here, it is said that the court may order the defendant to pay appropriate reasonable compensation instead of issuing an injunction under the consideration of national interest or public interest. And here are a few cases I would like to share. In the first cases, in this case, a power plant company was using a special equipment to filter out harmful sulfur dioxide from its exhaust gases, which turns out to be someone else's patented invention. The court recognized that the power plant company used the patented equipment without the patentee's permission, but the court refused to rule shutting down the power plant. The court believed that shutting down the power plant would be a bad idea because it will harm the local economy and public welfare, especially considering that the infringing equipment is actually aligned with the national policy of environmental protection. And as a result, the court ordered the defendant to keep using the equipment, but pay the patent owner a regular royalty until the patent expires. So it shows that the court prioritized clean air and community needs over strict punishment. And here is another case. In this case, an airport used curtain wall connectors in its construction, which turned out to be a patented technology. And the court agreed that it has already constituted patent infringement, but the court did not force the airport to replace all those walls because such order will cause massive cost and affect the basic needs of the public for transportation. Therefore, the airport was allowed to continue using the infringing device upon paying reasonable fees. And this is a classic case of prioritizing public interest over strictly enforcing the patent rights. So as you can see, in these two cases, power plants and airports are not just ordinary business. They are essential public service which we rely on basically every day. And if the court forced the infringer to stop using the infringing technology, large-scale reconstruction is needed, which will result in huge costs. And the judge basically says, like, look, we get that the patent owners deserve protection, but shutting down the critical infrastructure hurts everyone. So let's make this implementer pay fair compensation to the inventors and keep the factory and the airplanes running. So it is all about finding the balance, respecting the innovation by ensuring the inventors get paid, while keep the society basic needs. Yeah, that's the cases I would like to share, and I'll stop here.
Thank you very much, Butian, for bringing this example. And as I guess that it's very important to highlight here the importance to make a balance, aiming at protecting and incentivizing innovation, respecting and the innovations, and that negotiations such as payment of royalties, any kind, so any form, any way to have a negotiation aiming at having a balance in the market. So let's see as a final comment here regarding when a party is not satisfied with this compulsory licenses. So what can be done?
Thank you, Claudia. And I think the practice in China is pretty close to what is happening in Brazil. Like, well, under the Chinese law, the judicial remedies are available for both parties satisfied with the compulsory licensing decisions, including that the patent holders may challenge the grant of the compulsory license or challenge the licensing fees. And the licensees may also dispute the fee determinations through the judicial proceedings. But it should be mentioned is that applicants seeking compulsory license fees limitation that if the patent office reject the application for compulsory licensing, the applicant cannot challenge the decision before the court. That means the remedy is unilateral, and I believe the possible reason is that the court or the law want to reduce the procedural complexity or encouraging the negotiation between the patent holder and the implementers. So that is about the remedy. As we already explained that in China there is no actual case about compulsory licensing. Well, I mean the compulsory licensing in narrow senses has ever happened before. So we currently may not know what will actually happen before the court if somebody raised an opposition about the order of compulsory licensing and file to the court. Yeah, that's the what I would like to share. Thank you.
Okay. Thank you, Ning. Let's move on to the questions. We have a question here to Ning. And the question is, could you please demonstrate what Chinese court considers significant fees? So this is a very broad term, but so let's see what Ning and Butian may help us in clarifying this question.
Okay, thank you, Claudia, and thank you for the question. Firstly, I have to explain that the grant of compulsory license in China is conducted by the Patent Administration Department, and the Chinese court is not involved in this procedure. And I'm not quite sure what is the significant fees, because I can't remember I mentioned that. But I think it might be related to the remarkable economic significance that I talked about in the patent cross licensing. If that is the case, firstly, I have to say that as there is no actual practice in China now, so we do not know how the administration department will consider the patent to have a remarkable economic significance. But according to our experience and some similar cases in other sections of China patent law, we may provide evidence that this patent can greatly reduce the cost or can greatly enhance the efficiency of the production or could achieve a business success. And so we may provide evidence to prove that. And I hope I answers your question.
Yeah, well, thank you, Ning. We have another question here, I guess for all three countries. We have been receiving many questions, and so in case we are not able to have enough time, we will contact to revert with replies to this question. We have another question that is, in the cases discussed in the three jurisdictions, what were the royalties agreed? How were they calculated? Butian, Ning would like to please comment some.
Yeah, thank you. I explained two cases regarding the decision related to compulsory licensing issued by the court instead of the patent office. And in the Chinese legal framework, regarding the amount of damage or compensation, generally speaking, the legal framework is that firstly, we want to determine what is the benefits obtained by the infringer. And if it cannot be calculated, we can also determine what is the loss of the patentee. And if both of them cannot be determined, we will refer to the reasonable license fee that happens before. But as you know, apparently when we're talking about compulsory licensing, apparently no license has happened before. That makes it compulsory. So this makes the third one also unavailable. So the last one will be a judicial decision on compulsory on the compensation. That means the court will make the decision about the damage or about the royalty under its own discretion. And in the two cases I explained here, basically it's about the damage or the royalty is about 40,000 to 50,000 in each cases. But well, as Manta explained, every case depends on its own facts. And in the case I shared, it's about public affairs. It's about a plant and an airport. So the situation is about this amount, but I'm not sure if there will be a case regarding to the pharmaceutical industry, how the court or the patent office will calculate what is the royalty should be.
Okay, thank you, Butian.